Few words land harder in federal contracting than termination for default. Today we'll unpack why T for D is the most potent weapon in the government's arsenal, how it works across different contract types, and what to do when you receive that notice. Stay tuned.
Welcome to Claims and Sustains. My name is Teddie Arnold. With me is Zach Jacobson. This is a Seyfarth government contracts podcast where we help you navigate the toughest end of contract scenarios. This is going to be part of a multi-part podcast. We're looking to do 10 or 15 of these. There's a lot to unpack here when we're talking about terminations. Termination for default, termination for convenience. You've got cost and pricing issues that are all wrapped up in there and other sorts of liabilities that we're going to touch on. So today, episode 1, we're going to call it, What is Termination for Default? We're going to hit the big picture, the clause mechanics, and the monetary impacts. We're going to hit them fast with more to unpack later on. So let's get into the high level. Where are we in the world? Okay, termination for default is the government's harshest remedy. It's a contract remedy. It aims to make the government whole when the contractor fails. And the harshest remedy word is not a hyperbole. The default ripples through money, property, schedule, and past performance in ways that really other contract remedies don't. And so there's sort of two big contrasts to keep in mind from the get-go. Do you have default versus convenience, okay? Under a termination for convenience, the government can end performance when it's in the government's best interest, but it still owes the contractor something, and that is money. That's going to be the cost incurred up to the date of termination, a reasonable profit on those costs, any settlement expenses in wrapping up the termination. But what the contractor is not entitled to is the anticipatory profit that it would have earned had it continued on in performance. That's convenience, all right? Termination for default sort of flips that on its head. And the exposure is far greater for any work that was yet to be performed on the schedule before the contractor was ultimately defaulted. And then you got to think about your sort of contract type exposure, right? So different contract types carry with it different forms of exposure in a default scenario. Okay, so supply contract, right? Most draconian, right? So you're building a battleship and you're building it along a schedule, you're incurring a lot of costs, but you ultimately don't get paid, depending on the contract type, but you're probably not going to get paid until you deliver the battleship at the end of the contract. If you get defaulted under that contract, all the work in process, that work you've done along the way, you don't get paid for, okay? Most draconian. But then you've got a services contract and construction, a little different, right? The government is consuming the product along the way. So for every time the government consumes something, you're still going to get paid for that consumption, even if ultimately you get defaulted under the contract. So the default decision is discretionary, right? The government rarely must default you in any particular scenario. It can consider alternatives, right? And it often does, because default carries with it a lot of administrative red tape that the government's got to go through. It can extend your schedule. So if you're defaulted or you're on the chopping block because you're late, that you might get a schedule extension to accommodate you, and off we go, and let's avoid getting into any kind of default proceedings. The government can also do a no-cost settlement, right? That's where they basically settle the claim, they terminate you, but they're not going to give you any money, and you're not going to pay any of the sort of the default remedies. Or they can just terminate you for convenience, right? If it's in the government's best interest. But once it chooses a T for D, the consequences are immediate and they're wide-ranging.
So let's talk about one of those termination for default clauses, and maybe starting with FAR 52-249-8. That's default for a supplies and services contract. There's really two key paragraphs in that clause that are worth noting. The first is A1. That's the paragraph that has the late is late rule. Essentially, if you have a delivery date or performance deadline on your contract and you miss it, the requirement is not met, the government has a right to terminate, and they only have to give notice. That's something that a lot of people miss. There's no cure period under the late is late rule. The government has a right to terminate you on written notice. This is what we call a classic scheduled default. Now, A2 then is sort of the everything else. That's where you have failures other than pure lateness. So we're talking about, progress endangering performance or failure to comply with some sort of material provision, whatever it might be. It's a little more complicated. So the government can't just terminate you on written notice. The government must have to issue a written cure or a show cause notice to the contractor. It has to outline exactly what the basis is that the government is going to use for default. And they have to give the contractor at least 10 days to cure before terminating. And so that is the more common termination for default scenario that you're going to encounter, because there's a whole range of contract requirements that if a contractor fails to deliver on, the government could notify them that they consider it a basis for default and give them an opportunity to cure. So in our prep, you flagged two twists that you thought might be worth talking about. And the first one, of course, is anticipatory repudiation. It's something that doesn't come up a lot in government contracts. But essentially, if the contractor is clearly and unequivocally signaling to the government that they're not going to perform, they take their work crews off the job site, they pull out equipment, the government need not wait the 10 days. The government can issue a written notice of termination. Now, if the government's more conservative, they can still give you a cure period and give you a chance to go back, but it's not required. And so if you want to cure the repudiation, you need to get back on the job and resume work before the government notifies you of the basis for default. And the other one that you wanted to talk about was waiver, or the DeVito doctrine. So if the government waits too long after the contractor's missed a deadline, or after the contractor's failed to meet a requirement, and the contractor's continuing performance with the government's knowledge, the right to default can be waived. And the best practices for agencies to remember is they either need to act promptly, or they have to send at least a notice to the contractor in order to preserve their rights and ensure that they have the ability to terminate for default later, instead of inducing reliance through their inaction. And finally, we have commercial products and services contracts. It used to be called commercial item contracts, and it has an analogous provision in the terms and conditions clause, FAR 5212-4 at paragraph M, which is just called termination for cause. Termination for cause is similar to termination for default, but it's packaged up a little differently, and your rights as a contractor are going to be a little bit different. For one, the government is not going to be liable for supplies or services that it hasn't accepted. And if the cause is later found to be improper, it just automatically converts to a termination for convenience. And so it kind of takes a lot of the process and procedure out of the whole termination process and goes straight to a convenience termination if the default is later converted.
So let's talk about money, right? Because ultimately, what's at play here is money. So default's not just a label; it's a money machine for remedies, right? The government can invoke. So there's really three buckets that you want to be tracking in a default scenario. The first one, which you hear a lot about, excess reprocurement cost. Okay, very very catchy buzz phrase that often gets tagged with a default termination scenario. So what does that mean? That means the government can reprocure the same or similar goods or services, as soon as practicable. They can't wait too long at a reasonable price, and then they can send that invoice, that bill for that reprocurement cost, to the defaulted contractor for essentially the difference in what they had to pay above what they otherwise should have paid. The agencies do this in different ways. They might go down the line to the next contractor who was in line for award. That's one way to do it. They might just entirely recompete the procurement, right? And like I said earlier, a lot of red tape when you default terminate someone. So agencies really think long and hard before they do it, because they kind of got to scrap it and start over. So either way, they need a contemporaneous file showing the scope, similarity, and the price reasonableness of what they're buying from the new contractor. This is often the biggest dollar exposure that you face in a default scenario. Okay, that's one. Two is liquidated damages, right? This is in your contract, likely even absent a default scenario. So it's very common in construction. Liquidated damage is really an amount, it's a stated amount. It's a pre-estimated amount per day. That amount applies every day for late completion, right? It's enforceable only if it's qualified as a reasonable forecast at the time of award of the damages that the buying agency would likely sustain from late completion, right? So substantial completion, as you probably heard that term used, or any kind of beneficial occupancy in a construction contract will typically cut off any ability for the government to assess liquidated damages. They're really sort of independent of the default, something that would sort of go hand in hand with a late completion. Then you've got stuff like work in progress, progress payments, and title and possession of the goods at issue to sort of think about, right? So under the default clause, the government takes title to completed and partially completed supplies and manufacturing materials. So think like parts and tools and fixtures and plans and drawings and stuff like that. They can also recoup unliquidated progress or advance payments for the undelivered items. And then you got to be thinking about the conversion risk, right? So if the default termination is not legally justified, and this is like an argument contractors are likely going to make if they get defaulted, whether it's on procedural grounds or substantive grounds, that they can get that default converted to a termination for convenience, bringing with it recovery of incurred costs, your reasonable profit on the work performed, and your settlement expenses, stuff that you would get in a T for C setting. Finally, you want to be thinking about past performance and responsibility determinations will be impacted by a default termination. And then sort of as you go down the line in terms of how bad it can actually get, you may get a referral to a suspension of debarment official, and maybe, just maybe, you may get False Claims Act proceedings initiated against you depending on the severity. So the default can really reverberate across future awards. So treat every government notice like it's a pleading if you ever get one of these notices, and start building your case in the event that these dominoes start to fall.
So let's go through some, lightning tips and a few common pitfalls for people to take away from this. First, treating it like a pleading is a good way of thinking about it. You've got to calendar your deadline to respond, and you also have to make sure you respond. If the government serves a notice of default on a contractor, the government's already decided that they think performance is insufficient and they're going to terminate. And so treat that deadline as you would treat a legal filing, and make sure you have your response in place. And when you're looking at your response, make sure you're documenting the record. One of the things that a lot of contractors encounter are things that we would consider excusable delay. Poor weather conditions, labor unrest not caused by the contractor, things like that. Make sure you're documenting it and notifying the government timely in accordance with the contract. A lot of the contracts will have a clause that allows you to be excused under these circumstances, but they usually come with a notice requirement. And also, don't rely on informal extensions granted by a government official. Always make sure that any sort of understanding is gotten in writing. Make sure you have a bilateral modification to the contract if your schedule changes. Often, contractors think, well, we have reasonable reliance, we have substantial completion, but those are arguments you make in court after the fact. They're not going to get you out of the situation that you're in. And finally, make sure that you're preserving any arguments you have that'll get you your conversion. Because ultimately, if the government's real motive is unrelated to your performance under the contract, they just want to terminate the contract. And T for C is something that the government has a right to do, and you need to nudge them in that direction. And speaking of T for C, make sure that your charging is going to make sense during this time. When you're doing a termination for default, you're not thinking about a termination for convenience settlement, but that's ultimately where you might be going. And so make sure you're not charging your time in a way that's going to raise questions during the audit. Because ultimately, when you submit your termination for convenience settlement, the first thing the government's going to want to look at is how did you charge your time for all of these termination settlement costs that you're claiming.
So that's termination for default in a nutshell. What T for D is, how A1 differs from A2, why the money and the record matter from day one. So we're going to cover a lot more of this in future episodes. So up next in episode 2, we're going to drill into entitlement, when the government's truly justified in defaulting and when it isn't. So if you found this useful, follow and share it with your contracts teams, and see you next time.